I need to find something. There's a lot of reverb. Echo.
Several people will be participating remotely via Zoom in today's hearing. And because there is some feedback occasionally when we've got multiple parties, we will mute everyone except the person or party that is speaking so that we eliminate that feedback. So just so you'll know remotely, if you are not speaking, we will mute you at that point in time and then turn it back on whenever we need to hear from you. Okay. I think maybe the first thing to do, let's find out who we have present today and who, if it's an attorney, who you are representing. If you are pro se, well, likewise. Okay. The motions that I have today are a motion to dismiss filed on behalf of Mr. Mayer and Mr. Bellamy. Who is here in that matter?
Mr. Maher is here.
I'm sorry?
Mr. Maher.
Oh, right. Okay. My next motion is by Gail Patrick Hickman. Anyone here in that matter?
Good morning, Your Honor. I'm on mute, self-represented.
Okay. Barbara Fritz.
Good morning, Your Honor. Barbara Fritz appearing in pro se from California, making a special appearance.
Thank you. Lisa Reisner.
Good morning, Your Honor. Lisa Reisner, pro se, specially appearing.
Thank you. Miriam Galindo.
Morning, Your Honor. Rick Matrinsky for Dr. Galindo.
I'm sorry, give me your name again. It's hard to hear.
Matrinsky. It's I think it's spelled for you if you need.
I think I've got it. All right. The California Judicial Defendants.
Good morning, Your Honor. My name is Mark McGrady. I'm here on behalf of those 8 defendants.
Thank you.
Who's that? I don't see him.
Judge Philip Robbins and Joseph Woodruff.
This is Chair White on behalf of Judge Robinson and Judge Woodruff. I also represent Herbert Slattery and Amber Seymour.
Okay. Veritas, HHS, Child Support Services of Tennessee, and Jennifer Cole.
Yes, Your Honor, good morning. I'm Jennifer Daniels. Cole is my maiden name.
Okay.
So I'm here on behalf of myself, and I am the attorney with Child Support Services,
All
which
right,
is
thank
operated
you.
by Veritas.
Tennessee Board of Professional Responsibility and the Tennessee Judicial Ethics Committee.
Good morning, Your Honor. Rachel Appelt, present for both defendants.
Thank you. Dean Chris Guthrie.
Good morning, Your Honor. Tim Palmer here for Dean Guthrie.
Thank you. Dean Gonzalez.
Good morning, Your Honor. Tim Palmer again for Dean Gonzalez as well.
Thank you. Tamar Armanac. Is Mr. Armanac present or represented? Madeline Greenberg.
I'm here for Madeline Greenberg. John Maher.
I'm sorry, sir.
John Maher for Ms. Greenberg.
Thank you. Judge Joe Binkley.
Good morning, Your Honor. Jonathan Cole here for Judge Binkley.
All right. And the third-party plaintiff, Mr. Daniel Greenberg, is also present via Zoom, I believe. Is that correct, Mr. Greenberg?
Sorry, I didn't hear the question.
You are Mr. Daniel Greenberg, correct? The third-party
I
plaintiff?
am.
All right, thank you. All right. All right.
So do we have the notice that lists all the parties?
I'm sorry, sir, I didn't understand you. What was your question?
Do you have the notice that you can share that lists all the parties that are present today?
Oh, you just heard all the parties that were present, or their attorneys. And we'll be going through each one of these one at a time, so you'll get the information
All right,
as each one goes through. All right, let me, if you'll mute everyone that's, I'm going to mute while I make my opening remarks. We're here today on these motions to dismiss that we have just gone through the list of. They've been filed by, I believe we said 12 or 15 third-party defendants. In these motions, the defendants request the court to dismiss Mr. Greenberg's third-party complaint based upon Rule 12 motions. The case was originally brought by ROBERTSON, ANSCHUTZ, and others as substitute trustee, holding funds, surplus funds after a foreclosure sale. The defendants, Mr. Daniel S. Greenberg, Carla Gifford, the estate of Marion Wise, and the state of Tennessee were named as parties by Mr. Greenberg, third-party defendants, or were named in the original lawsuit as having an interest in the funds. Then Mr. Greenberg filed a pleading that was entitled Answer and Cross Claim, naming 49 persons or entities as cross defendants, in reality third-party defendants. As I said, the pleading was erroneously titled a cross claim. In accordance with the rules of Tennessee civil procedure, it's actually a third-party complaint and will be referred to as such by this court. And the 49 entities will be referred to as third-party defendants. All right. I think we are ready to begin our hearings in this matter. We will take them in the order that I went through originally. So that the first motion will be the motion to dismiss filed by Mr. Meyer and Mr. Bellamy. And I'm sorry if I mispronounced your name there, sir.
That's fine, Your Honor. That's Maher.
Maher. All right. I'll try to remember and get it right the next time.
Can I say anything before he starts regarding the process?
We are going to mute all of the parties that are participating remotely until Mr. Meyer has finished his presentation. Then I will hear from you, Mr. Greenberg, after Mr. Meyer has completed his presentation.
Morning, Your Honor. John Maher from the Montgomery County Bar. Essentially, Mr. Greenberg, with regard to Mr. Bellamy and myself, has filed a third-party suit against us, claiming that as attorneys, and in filing it, not in this action, but in filing the motion to domesticate the foreign order, are somehow eligible to be sued. That is essentially it. His claims in this stem from, and if you refer to my brief, he puts in there additional conspiracies to perpetrate fraud on the court, including civil racketeering, human trafficking, real estate fraud, wire fraud, interstate commerce fraud, among others, are also further alleged against the cross-claimants. And it's just how those play into this action is just unclear, because there's no factual allegations that myself or Mr. Bellamy were anyway involved in any of those things, or any facts to support that any of those things even occurred. It's just simply he's thrown out some allegations as to pure legal terminology of possible causes of action with no support whatsoever. And that's just the whole gravamen of this. There's just no factual support for it whatsoever. He doesn't name us specifically as doing anything anywhere in, it just names us as a group of defendants and says they've all been involved in this without any factual basis whatsoever. And in that case, without any factual basis whatsoever, you just cannot sustain this action. And without naming that, and more particularly with regard to fraud, as we pointed out in there, under the Brown case, they have to specifically acknowledge and lay out what it is that is the fraudulent act with specific factual findings, more than just a notice pleading. And a notice pleading just can't be, you committed a tort against me and I sue you, which is essentially what he said here. He named a bunch of various torts and said all the defendants did it. And just the ludicrousy of 49 defendants going from Vanderbilt to the Board of Tests and Responsibility to all the California judges with no factual support just shows that this is just a ludicrous claim and another way for Mr. Greenberg to try to avoid the judgment being entered here in Tennessee and moving forward. My client's been going through this for years, and I think this is just tortious behavior on his part in continuing to file these. And one of the things we asked for in our sanctions besides attorney's fees was we asked the court to appoint a special master if he thinks he wants to file any more lawsuits. And we used the Hooker case to establish the court's right to do that. But if he wants to continue to file these crazy filings against 49 individuals, he needs to go through the special master, and that needs to be vetted before he's allowed to file those. So that was the sanction we asked for in this case. And I think it's very reasonable in this case, if the court looks at the history, how many cases are coming in here, and just the fact that he chose to even file this in an interpleader action, rather than just defend the foreign decree.
Underlying,
the underlying foreign
initial
decree.
pleading in the
Right.
case, yes.
So that there was no reason for that, And all the remedies he seeks are just far outside of this court's purview. And so we'd ask just to dismiss on that basis, Your Honor.
Thank you. All right, let's let Mr. Greenberg respond.
Okay, before we get started, all I hear is echo.
Mr. Greenberg, I don't know what to tell you. I think everybody else can hear us just fine. Do you want to respond to Mr. And Mr. Bellamy's motion to dismiss? You have
Yeah, I
right
want.
if you want to respond to their
Yes, I do.
Set out in that motion.
First, he makes claims that no factual facts were pled. That's not true. As you are aware, the transcript from 6/17/17 is included in the complaint. That is a specific set of facts. Will the court acknowledge that? I've requested that the court take judicial notice.
Now, and I will make a ruling, but you go ahead and make your argument, and if you say it's included, I'll consider that. Go ahead and finish your argument.
Okay, well, I have some other issues regarding judicial notice.
Well, he did not raise
The due process. I'm sorry?
His motion does not raise judicial notice. I'm not sure.
But I'm raising that to refute his claim.
Okay, go ahead.
And more importantly, he is aware, and of the several other courts, of the specific facts. Okay. So his assertion regarding the sua sponte appointment of the guardian ad litem is a specific fact of fraud. Hold on, I got my notes. Yeah, I did want to mention that my intent to appear, I informed the court that I wasn't properly noticed because I have no idea who's present today.
Well, we just went through all that, but you'll hear each one of them as they.
But I need to be properly notified so I could prepare for each person that was shown. I have no idea who showed up. I mean, I understand you just told me who was there, but I needed to know in advance who was going to be there. So his assertion that I have not made any factual claims is refuted by transcript that is in the record. Would you like me to read those facts to you?
I think, are they included in the record, Mr. Greenberg? You're saying they're included in the record, is that correct?
I am saying they are included in the record.
Everything that is in the record.
Will you?
Excuse me, go ahead.
Will you acknowledge that they are in the record, or do you want me to read them into the record?
If you say they're in the record, that is fine, but today we are here just to argue these motions. So is it something that you have filed that is in the court record?
Yes, but that stems to the fact that he's claiming that no facts were pled, and that's the reason for his doing. And that's simply not true.
Okay. And you say they are pled in your third-party complaint?
Yes. Would you like me to show you?
No, I have it, and I've read every word of it.
Okay, so you can or cannot confirm that they are in there.
I'm not at this point going to confirm that, Mr. Greenberg. I'm just telling you I've read your third-party complaint and everything that's in it. If you filed it, I read it. You don't need to reread it to me.
And as far as the proper procedure, I also filed for disqualification of Mr. Mayor because he cannot represent himself and Carla and my daughter in this matter. He has a clear conflict of interest.
Well, we are here only today on his motion to dismiss your claim against him. Your disqualification is not for the court today. So let's limit ourselves to the motion to dismiss.
But it was before the court, before his motion was before the court.
The only things set for hearing today are the motions to dismiss.
Right, and so that's procedurally inappropriate. He can't get dismissed after he's been disqualified, or he can't be disqualified after he's dismissed.
Okay. What's your next point?
So you won't concede to the fact that that's procedurally inappropriate?
I will make a decision on that based on your argument.
Okay. So further specifying the claims, Julie Palafox on June 6, 2017, clearly acted outside the scope of her duty by playing a mental health professional from the bench. She also took or made extrajudicial activities of going and talking with probably most likely Gail Hickman when she assigned him as a guardian ad litem, rather. That's also in the record. That's a specific act of fraud. I need to go through the case law that specifies that. It's in the.
I think you have specified that. No, you don't need to do that.
Okay. As far as the tolling damages, he was correct in that he's trying to domesticate this fraudulent order in several courts across the state of Tennessee. Making matters worse, part of it has already been domesticated. This fraudulent order has already been domesticated in Williamson County. He's aware of that too. He's aware of the fraud that took place there to register that foreign decree. That's why he is part of the conspiracy as well. He went before the Third Circuit with this fraudulent order and tried to register. And it's not clear as to what the Third Circuit is presently doing other than deferring to this court to domesticate a fraudulent order, which is some sort of fraud in itself. So the confidentiality breach and tolling harm caused constitutional harm to my children and myself. Emotional intent or emotional distress and intentional infliction of emotional distress. Obviously, the tolling constitutional harm is the right to parent my children. That's a specific claim. Let me pull up the document because I'm not able to do this off the top of my head.
What document are you pulling up, Mr. Greenberg?
My motion to counter that has all the language.
You're talking about your response to his motion?
Yes. I've sufficiently pled facts supporting his conspiracy and fraud claims. Defendants conspired with others to properly enforce his void California judgment, further violating plaintiff's due process rights. Defendant's motion should be denied. Plaintiff has sufficiently alleged facts showing defendants conspired with a California trial judge to violate his constitutional rights to perpetuate enforcement of California judgment. I said that just a bit earlier, but defendants had knowledge that the California trial judge had improperly appointed a guardian ad litem over a plaintiff, a competent adult, without notice or hearing during divorce proceedings. This rendered the subsequent California judgment void ab initio for lack of personal jurisdiction and violation of due process. For a judgment is void judgment if the court rendered the judgment lacked jurisdiction of the subject matter or the parties or acted in a manner inconsistent with due process. That's Federal Rules of Civil Procedure 60B, or the Constitution. Judicial officers lose any judicial or state immunity by acting in clear absence of personal jurisdiction. These are all facts that were pled in support. Well, the facts that these events occurred have been pled, and it needs to be determined by an independent trier of facts and law as to whether or not they constitute a tort.
Anything else, Mr. Greenberg? And we'll move on to the next motion to dismiss. And when we get to the next motion to dismiss, if your argument or your response to that motion is the same as the one you have just given me, you can just let me know that, and I will consider that as, in response.
There are other specifics to specific facts to other individuals
well,
involved.
You certainly are free to raise those if there's something that you need to, that's peculiar to one particular defendant. Certainly raise those issues when it is appropriate.
Okay.
Is that all in
Images,
connection
no.
with particular defendants?
Yeah, I need
Mr. Meyer and Mr. Bellamy.
Right, yes.
Okay. So are we ready to
So
move on?
I read it. I need to. So in this very action, there's an attempt by defendants Gifford, Meyer, Bellamy, and the state of Tennessee to further deprive the plaintiff of both property, interrelated funds, and the person by attempting to use Chancery Court to enforce a decree that was not properly registered under UIFSA. See Jolly be Jolly. So this court is aware that these facts were pled, and we need to determine if this alleged facts will survive a Rule 12 motion, which they do because they're properly pled.
Anything further then on with regard to this particular motion?
Everything else is included in my response.
Okay.
But I'm not sure. I don't think that he brought up anything new.
All right. Thank you. Then we'll go on to the next motion. All right.
It's terrible.
All right. Mr. Hickman, I believe you are the next in line. Can you hear me, Mr. Hickman?
Yes, I can, Your Honor.
All right. I'm ready to hear from you.
Thank you, Your Honor. Good morning.
Good morning.
May it please. I'm a retired Orange County Superior Court Commissioner Judge. The facts of my case are few. Judge Palafox appointed me sua sponte to serve as guardian ad litem. Greenberg notified me by minute order. Upon receipt of the minute order, I wrote her a letter copied to Mr. Greenberg and his wife, notifying them that I declined to accept the appointment. 2 weeks later, on June 27th, she vacated my appointment. These documents are attached to my motion. And I never served as guardian ad litem for Mr. Greenberg. None of the criteria for jurisdiction over me is applicable. I've set that out in my brief. Second alternative ground, the facts support a claim for relief. And if I might add a footnote, in my 54 years as a member of the legal profession, I've seen facts. They're so few. And in my opinion, indicate clear ruling. And I'm happy to say I now submit it to the court's determination.
Thank you, sir.
Thank you.
All right. Anything you want to add, Mr. Greenberg, based upon Mr. Hickman's motion or in response to Mr. Hickman's motion? Okay, go ahead. Mr. Greenberg, can you hear me?
Yeah.
All right.
Yeah, okay. You can hear me now. I was muted. Okay. I'm glad that Mr. Hickman was able to admit that he was sua sponte appointed by as guardian ad litem by Julie Palafox, which is a clear violation of my due process rights. That reason alone should be dismissed. As far as his jurisdiction, he was surrendered jurisdiction by his fraudulent acts, and now that they're being trying to investigated in Tennessee, he surrendered to the state of Tennessee. His assertion that he never acted as the guardian ad litem is refuted by specific facts that were alleged, and I have email correspondence with him acting as the guardian ad litem, and then his subsequent withdrawal is not disputed. It's fraudulent participation, the ruse of dignity and liberty, ADA discrimination is not disputed. It's alleged.
Okay. Anything further?
Refer to whatever else is in my pleading response to.
Okay. All right, then. We'll move on. Thank you, Mr. Hickman. I'll consider your motion and Mr. Greenberg's response, and I will file a written order in this matter, setting forth whatever my decision may be. Thank you.
Thank you, Your Honor.
All right.
Is that decision going to be declared today, or is this just something going to happen?
I will put, it will probably not be declared today, Mr. Greenberg. I like to listen to everything and think about it, and then write something that is clear to everyone about what my reasons are. So probably not today, but very shortly, okay?
Yeah, I just wasn't aware if you were going to make an adjudication in front of us, or if this was something that...
I will rule on these motions that are set today within a very short period of time.
That's fine. That's why procedurally I wasn't looking.
All right. Now, let's move on to our next one. Ms. Barbara Fritz. Ms. Fritz, can you hear me?
I can, Your Honor. Thank you.
All right. Ms. Fritz, I'm ready to hear your argument.
Yes, Your Honor. First of all, I am a semi-retired family law attorney. I have never been, Your Honor, to the state of Tennessee. I've never had any property or any interaction with the state of Tennessee. I also noted in my response that there was a failure to state a claim. I didn't exactly know what was being asked of me or why. It has been years since I was on the case. Actually, January 2013 was the last time I appeared, and I only appeared for 2 or 3 hearings matter. Again, I could not ascertain the fact allegations made against me. I just didn't know what they were. Again, I haven't been on the case 2013. I think there's a statute of limitation that should apply in Tennessee as well as in California. I just don't want to be a part of this case. And I want my participation to be dismissed. I have nothing to offer to help Mr. Greenberg, and I don't want to be part of this action, if at all possible.
All right. Thank you. Mr. Greenberg, would you like to respond to Ms. Fritz?
Yes, I would. So Ms. Fritz was Carla's counsel for a number of years. So she was party to this action that ultimately led to fraud. As far as her participation in the state of Tennessee, again, these orders were made in California and are trying to be domesticated in the state of Tennessee and have been partially domesticated in the state of Tennessee. Mail fraud.
Mr. Greenberg, I think your microphone is hitting against perhaps your shirt or something, and it's kind of giggling. Thank you very much. That's better, I think.
Okay. All right, I lost my train of thought.
Well, I'm sorry. Gather your thoughts and continue.
Not that I had a train of thought to begin with, but okay. So she represented Carla, so she can't claim that she is not part of this ruse, and the ruse is clearly pled with thing.
Okay. All right.
Hold on, and there's more for her.
Mr. Greenberg, all of your arguments, some of the things you've said in response to other motions may be applicable in each of these motions, so I will consider that, okay? And so feel free to add anything you want to add. This is your opportunity.
Yeah.
Is there anything further?
Yes.
Okay.
Attorneys perpetuating frauds upon the court are not immune from liability. So the fact that this fraud is tolling, as evidenced by the fact that I do not have custody of my children, nor do I have control of my estate and my money, this woman's participation is part of the fraud, and she's not immune from liability.
Okay.
Attorneys can be sued along with original fraudsters under these circumstances. Furthermore, I think she has an obligation to inform this court that fraud has occurred. And by not doing so in her presence here now, she's committing fraud. Do you follow that?
Yes.
She's aware of fraud. She's here, but she's not admitting to it.
I understand your argument.
So subsequently, in a subsequent action, I will probably end up suing her again until we get to the point that the order is fraud. But Judge Robinson, Woodruff, they didn't want to have anything. They didn't think I had a right to come in and challenge a void order. and as a result, she's to be held reliable, or not reliable, liable. That's, I mean, it's all in the pleading,
All right, thank you. All right,
but you're just going to ignore it.
all right. The next motion is by Ms. Lisa Reisner or Risner, I'm not sure.
Lisa Reisner, Your Honor.
All right, Ms. Reisner, I'll hear from you.
Thank you, Your Honor. Especially appearing just to restate what was stated in the moving papers under Rule of Civil Procedure 12.02, subsection 2. There's a lack of jurisdiction. I have not engaged in the conduct as identified in section 20-2-2223 that serve as a basis for any personal jurisdiction over me in this matter. I was for the Giffords attorney of record until April 13th of 2015. I substituted out of the action prior to the final conclusion of this case, Your Honor.
Okay. Anything further?
No, Your Honor, I submit my declaration as moving papers.
All right. All right. Mr. Greenberg, anything you want to add based on what Ms. Reisner has said? Just a moment, Mr. Greenberg. Let me get you unmuted. Just one moment. All right. Now, try again.
Her assertion that she's not under this jurisdiction is fallacious. Under Tennessee Code Section 22-223, she has caused torturous energy in the state of Tennessee by an act or omission outside the state of Tennessee. And without the equitable estoppel, the ninth cause of action that I've asserted, she will cause additional torturous injury in the state of Tennessee by an act or omission inside the state of Tennessee. And that's 20-2-233, Section 3.
Okay.
So, hold on, there's more. Regarding her motion to dismiss, I only am required to test the legal sufficiency of the complaint, not the strength of evidence. This court has to accept the facts as true and construe them favorably to the plaintiff. Dismissal is inappropriate unless the plaintiff can prove no set of facts entitling him to relief. The set of facts has already been submitted in the pleadings as well as in the court transcript that I've tried to obtain judicial notice and is in this third-party complaint. So that transcript constitutes a set of facts. So the assertion that there is no set of facts alleging this fraud upon the court is absurd. Why it continues is I don't know.
All right. Anything further? Other than what you've already told me.
No.
All right.
I mean, it's all in the pleading.
All right. All right. Ms. Fritz and Ms. Reisner then, that concludes your motion. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
I would request.
All right. The next motion is by the third-party defendant, Miriam Galindo.
morning, Your Honor. Rick Madrinsky, Nashville Bar. We filed a couple of arguments here in our motion to dismiss, and I'm just going to hit the high points briefly if I could. As an initial matter, Dr. Galindo last interacted with Mr. Greenberg in 2014, almost 10 years ago at this point. Of the many possible causes of action that Mr. Greenberg has attempted to plead, fraud, for example, the statute of limitations is 3 years. Civil conspiracy, it's 1. I think we're well outside the statute of limitations for any of the causes of action that he attempts to plead. In the alternative, I'll just echo that he has failed to state a claim against Dr. Galindo. The only place she's mentioned in the entire pleading is in the caption of the case. Insofar as he's pleaded some criminal statutes that don't properly raise a civil cause of action, those causes of action should be dismissed, and the civil causes of action are full of legal conclusions or just conclusory statements, which once again do not connect at all to Dr. Galindo. And then finally, as for personal jurisdiction, we don't believe this court has personal jurisdiction over Dr. Galindo. She has never conducted business in Tennessee. She does not own property in Tennessee. And none of the acts or omissions that could possibly be construed as pled against Dr. Galindo occurred in the state of Tennessee. Thank you very much.
All right. Thank you, sir. All right. You're free to go if you like. All right. Mr. Greenberg?
Yeah, so there's seems to be some confusion about fraud upon the court. There is no statute of limitations. Is the court willing to concede that at this point, or do I need to read that into the record as well?
You're free to make whatever statements you want to make.
Okay, let me find it. A little noise outside. Yes. I'd like to read 2 things into the record. Following the simple guide of Rule 8F, that all pleadings shall be construed to do this substantial justice. The federal rules reject the approach that pleading is a game of skill in which one misstep by counsel may be decisive to the outcome, and accept the principle that the purpose of the pleading is to facilitate a proper decision on the merits. The court also cited 8F, which holds that pleading shall be construed to do substantial justice, lest the citizenry lose faith in the substance of the system and procedures we use to administer, we can ill afford to confront them with a government dominated by forms and mysterious rituals, and then tell them they lose because they did not know how to play the game or should not have taken it as word. Regarding the fraud on the court, I have to find the specific syntax. Yeah, so Federal Rule of Civil Procedure 60D3 allows the court to set aside judgment for fraud upon the court without any time limit. This reflects the principle that fraud upon the court is anathema to the judicial system itself. So the fact that they claim that fraud has a statute of limitations is erroneous. Again, there's ample case law cited in my pleadings that I can't locate right now that refute that claim. That really has nothing to do with whether or not I stated a claim for which survives Rule 12. I'm at least entitled to obtain additional discovery and or leave of court to amend my pleading such that additional facts can be included. Again, this is not a game of skill, and I don't know the rules, so if I didn't put that on this date they did this, automatically they get dismissed and they're not obligated to be held responsible. That's not really substantial justice.
All right.
But
anything else? All right.
yeah, I also have my issues with proper notice. I'm just now learning today who is present. There's no way I could have properly.
Did you receive copies of all these motions to dismiss? You've got a copy of all of them, correct?
Yeah, I do have
the
copies.
notice today said that we would hear all motions that were filed by November the 10th. So you were given that notice, correct?
Yes, I was given that notice with no specificity.
Okay.
Am I supposed to know which ones are filed prior to November 10th?
They have the filing date on them, sir. Okay. Now the California Judicial Defendants motion.
This guy.
Good morning, Your Honor.
Good
My
morning.
name is Mark McGrady. I'm with the Williamson County Bar. To specify who I mean by the California Judicial Defendants, I'll go through them briefly, although it's in the paperwork.
Okay.
That would be the Honorable Kathleen O'Leary, the presiding justice of one of the divisions of the California Court of Appeals, the Superior Court of California, Orange County itself, which I would refer to after this as just the Superior Court. The Honorable Marie Hernandez, who is Maria, I believe, currently the presiding judge of the Superior Court. The Honorable Theodore Howard, who was a judge of the Superior Court and had this case when it was filed early on, but then it was transferred to Judge Julie Palafox, one of the other defendants and one of my other clients. The Honorable Lon Hurwitz, who was a judge of the Superior Court and was previously the presiding judge of the Superior Court. The Honorable Eric Larsch, same thing. He is a judge of the Superior Court, but was formerly the presiding judge of the Superior Court in Orange County. As I mentioned, Honorable Julie Palafox, the judge that issued some of the rulings that Mr. Greenberg takes umbrage with. And then the final client of mine is David Yamasaki, who is not a judge, but he is the court executive officer of the Superior Court, which I believe would be the equivalent of a clerk here in Tennessee. So those are who I am representing. We filed a motion to dismiss on a number of grounds, the first of those being lack of personal jurisdiction over all of these defendants. They were involved, well, some of them were not involved in Mr. Greenberg's case, but he and his former wife where residents of California filed Ms. Gifford filed a petition for dissolution, asked for an adjudication about property and child support for their children. Mr. Greenberg filed a response also naming 2 properties in Tennessee that he claimed that should be set aside as his sole property. And so the California courts were asked to adjudicate property matters here in Tennessee and to decide child support. Subsequent to, I don't know that it's in the facts. At some point, Mr. Greenberg and Ms. Gifford have contacts now with Tennessee as well, and maybe reside here part-time. But at the time that this action was filed in 2013, they were residents of California, asked the judges, the judicial system in California, to adjudicate the dissolution proceeding between them. And Judge Howard, while he had the case, and then Judge Palafox since then, did so. One of the things that Mr. Greenberg is most upset about was the appointment of a guardian ad litem over him, which occurred in June of 2017. And Mr. Greenberg has referred to the transcript. We actually submitted it as part of our motion to dismiss. The California Judicial Defendants don't have anything to hide in terms of what happened. Mr. Greenberg was warned during the hearing on that day that if he continued to disrupt the proceedings, the Judge Palafox was going to consider appointing a guardian ad litem so that the proceedings could proceed in an orderly fashion. When interruptions continued, she paused the proceeding. When she returned to the bench, she announced she was, in fact, appointing a guardian ad litem for Mr. Greenberg pursuant to a California statute that she cited on the record, and the case proceeded. And then, issues of support and so forth were adjudicated. I think some of those were done in 2018. The last really involvement of the judicial system in California was that they had to make a determination about who had ownership rights or who had rights in the properties here in Tennessee, and those orders were issued in 2019, more than about 4 years before this action was, or the claims, this third-party complaint was filed against these judicial officers here in Tennessee. So similar to the other California defendants you've heard from already this morning, my clients make the same statements that there is not personal jurisdiction over them here in Tennessee. Acknowledge Mr. Greenberg's point that there may be an effect of those decisions that were made in California on Mr. Greenberg here in Tennessee, but that is not the test. The test is, did they, as the court is well aware, there's a due process under the constitutional requirement that you have to have minimum contacts with a state for that state to exert jurisdiction over the individuals, and the judges did their duties in California, and the fact that there's an effect on, maybe an effect on Mr. Greenberg here in Tennessee does not mean that they can be hailed into court here in Tennessee for adjudicating the matters that were presented to them by the parties. I've cited a case from the U.S. Supreme Court on minimum contacts where the situation was where there was a confiscation of property at the Atlanta airport. The defendants mostly resided in Nevada and tried to sue the officer who confiscated the property in Nevada, saying, hey, this affects our way of life here in Nevada because you took our money in Atlanta, and the Supreme Court said that is not sufficient minimum contacts. The fact that there is an effect in another state does not mean that you have jurisdiction over these people who took their action elsewhere. I acknowledge that Mr. Greenberg has cited a Tennessee statute that he claims gives jurisdiction. Of course, the Tennessee statute, even if it did read as Mr. Greenberg says, could not confer jurisdiction that's not allowed by the Constitution. So the first thing you have to look at is their minimum contacts for due process purposes under the Constitution, and there's not against any of the California judicial defendants. Secondly, the statute is actually misconstrued by Mr. Greenberg. He talks about the fact that an action outside of Tennessee causes an effect in Tennessee, but he omits the discussion of the second part of that statute, which talks about someone who is doing business in Tennessee or does business with Tennessee people or is is doing things with the idea of affecting business in Tennessee. It's not enough that there's an effect in Tennessee by an action done somewhere else. The whole statute makes it clear that these California defendants do not fit within it. Mr. Greenberg, I think in his response to our motion, talks about the fact, well, people are trying to register this judgment in Tennessee. That may be true, but it's not the California defendants that are trying to register this judgment in Tennessee. They did their job in California and they're done. So what other folks have done does not give jurisdiction over the California defendants here in Tennessee. Our second argument is basically statute of limitations. Mr. Greenberg does not like the appointment of guardian ad litem that occurred in 2017. Under any theory, that's either fraud or a civil rights violation. Civil rights have a 1-year statute of limitation, which is long past. Fraud has a 3-year statute of limitations. Mr. Greenberg responds, well, it's a continuing violation, not by the California judicial defendants. They have not acted in the case since 2019. So there's continuing violation means you continue to do constitutional violations yourself, that particular person. It doesn't mean that somebody else is trying to enforce it. Or it also doesn't mean that because there's an effect that continues, that doesn't give continuing, that's not a continuing violation that in effect tolls the statute of limitations. Mr. Greenberg also responded about, well, they've been hiding what happened. Well, the appointment of the guardian ad litem occurred in open court in front of him. And the proceeding continued on, and he actually handled his own appeal of that case and didn't even bring up the appointment of the guardian ad litem issue when he appealed the dissolution matter. And so then, with respect to the property order, again, that was done on the record, so there wasn't any concealment of facts that would toll the statute of limitations in this case. There's allegations in the third-party complaint about civil conspiracy. That depends on the gravamen of the claim. So for personal injury, it would be 1 year. For effect on property, it would be 3. Either way, the statute of limitations is passed against the California judicial officers. Kind of a unique thing here is that Mr. Greenberg filed a civil claim in the Federal District Court for the Middle District of Tennessee. And one of the people it's kind of like here where some people may be named in the caption, other people named in the body of the complaint, but one of the things he was complaining about was the appointment of the guardian ad litem by Judge Palafox in that federal proceeding, which the case was dismissed on procedural grounds at the district court level, but then on appeal, the Sixth Circuit basically reached the merits of his claim against Judge Palafox and ruled that that his claim was without merit. So Judge Palafox at least has a res judicata argument as well, that he's already litigated his claims against Judge Palafox once and lost, and he doesn't have the right to do it again. And probably most importantly for my
Object to
client,
that is false.
Go ahead.
I in response to that, I submitted what the complaint said. I've submitted the Sixth Circuit opinion so the court can read what was said and not said.
Okay.
For the California judicial defendants, the main, probably most important defense, and really most important to our system of government, is the defense of absolute judicial immunity. That Mr. Greenberg, I think his theory is that because the decisions by Judge Palafox in his mind were improper, that therefore there's a lack of jurisdiction and somehow it's a fraud on the court. But that's not what a fraud on the court is. I mean, Judge Palafox, it was the judge handling these cases at the time she issued these rulings. So I cited a case from about the only one I could find from the district court in Ohio that basically says how can a judge commit fraud on themselves, basically, is what his argument is. The Judge Palafox made the rulings. That's not fraud on the court. You can disagree with it, but that doesn't make it doesn't take away the jurisdiction of the judge to make the decision she made. And so the ruling she was making that Mr. Greenberg disagrees with were done in the course of a dissolution proceeding where all the parties were asking to decide custody, to decide child support, to decide the division of property. Those are all things that the judges had jurisdiction to decide. And so you can disagree with those decisions, but you can't sue the judges under our system of government, either under Tennessee law, under California law, or under federal law for making decisions that you disagree with that are clearly within the jurisdiction of the judges. It's hard to tell why some of the presiding judges were sued. The only connection I can figure out with Justice O'Sullivan is she wrote the unanimous opinion in his appeal. She certainly would have jurisdiction to have decided the appeal, so she's entitled to judicial immunity. Some of the other judges at the Superior Court level, Mr. Greenberg doesn't, he basically says for a couple of them, they failed to properly supervise Judge Palafox or discipline her. Well, that's, as the court knows, one judge doesn't have the ability to step in, and even if they're the presiding judge over a court and discipline the judges, there's a system for that, but it's not the job of the presiding judge to step in and interfere in another judge's case. So, and then there's no allegation really with the court executive there, what it is that he supposedly did. So, and court executives can be entitled to the same kind of immunity as the judge is. So we cited some cases to talk about quasi-judicial immunity that should apply to the clerk as well, to the extent there's actually any kind of allegation out there. Those are probably the four most important defenses. We cited in our materials things that would create problems for Mr. Greenberg's complaint in other respects. He asked for injunctive relief. Under 1983, you have to either allege that there was a declaratory order that was violated or one wasn't available. He hasn't pled those things. Lawsuit against the Superior Court of California is an action against the state of California, which cannot be brought in Tennessee, either under 1983 because the state is not a person under 1983, and recent Supreme Court cases have said without the consent of a state, they cannot be sued in another state's court, and that would prevent the action from going forward against either the court itself or the officers, the judicial officers in their official capacity, which he has named because he's trying to sue the state. His argument is, well, they tried to register the judgment. California didn't try to register the judgment. Ms. Gifford may have tried to register the judgment here in Tennessee, but the state of California did not, and they have not consented to being sued in this court. It's hard to tell what Mr. Greenberg's, what they're grounded in. To the extent they're under state tort law, we've argued that the state with the most contacts is California, so California substantive law should apply to any such claims. And under California law, like Tennessee, they have their governmental immunity or governmental liability acts, and one of the requirements of California is that before you sue government agencies or officers, you have to have given notice of a claim. And there's no allegation that Mr. Greenberg has satisfied those requirements in California. So that's an additional reason why any California claims he might have tried to assert are not proper. And then finally, the court doesn't have to get to the substance of the claims about against the California judicial defendants for the reasons I've already outlined. But if the court gets that far, there's no allegations in the complaint at all against the Superior Court itself, Justice O'Leary, Judge Howard, Judge Hurwitz, or Judge Yamasaki. Just a failure to supervise claim against former supervising Judge Larch and current presiding Judge Hernandez. And then with respect to the whole due process claim, because the guardian ad litem was appointed he was warned by Judge Palafox that day of the proceeding and before that, that if he didn't stop interrupting the other parties in the court, that the court would consider a guardian ad litem being appointed. So he had notice of what could be coming, and he had an opportunity to be heard throughout the proceeding. And in fact, he was heard from throughout the proceeding, even after the guardian ad litem was appointed. We've cited a case, I think it was from the Second Circuit, that talks about that in a similar case where a guardian ad litem was appointed in a case where the court was familiar with the parties. The court themselves knew what was going on in the case, that due process was complied with. So despite Mr. Greenberg's
I object to this misstatement of facts.
All right, go ahead, sir.
There was there was notice and an opportunity to be heard during the proceeding about the guardian ad litem being appointed. And interestingly enough, then when Mr. Greenberg handled his own appeal of that matter directly to the California Court of Appeals, he didn't even bring it up. He uses the word fraud a lot. We discussed what it means to be fraud on a court. This isn't fraud on a court, what he's alleging. And it also has to be specifically pled under the Tennessee rules, and it's not. He just throws out the word civil racketeering, but doesn't cite the statute, which is also a requirement when you're basing a claim on a statute. And he also cites human trafficking, but he doesn't. As a non-lawyer, he doesn't have the right to, if that's something that he thinks his children have been trafficked, he doesn't have the right to assert that kind of claim in any event, and doesn't really plead it. So for all these multitude of reasons, the California judicial defendants asked that the claims against them be dismissed.
Thank you. All right, Mr. Greenberg.
Okay. I guess one of the things that stuck out was his claim about the Sixth Circuit. That's just false. I was thrown out because of the domestic relations exclusion clause. There was no findings by the court. It was dismissed. Further, it doesn't matter. I can bring a claim for fraud upon the court at any time in any court. It's subject to direct collateral attack. You have all this case law that I've specified numerous times. Why he's allowed to get up there and state these claims is absurd without objection. Furthermore, res judicata consequences will not be applied to avoid judgment, which is one from its inception is complete nullity and without a legal effect. So his assertion that there's some sort of statute of limitations on there is absurd. Regarding the sua sponte appointment and Judge O'Leary's involvement in this fraud upon the court, she actually presided over the case law that was cited, marriage of Herms, holding that a judge at Orange County Superior Court erred in declining to hold a hearing to determine if there was merit to a wife's contention that her husband lacked mental capacity to determine he wanted a divorce. Basically, that's the whole sua sponte appointment of a guardian ad litem, which is a violation of due process. It violates adults' prior to due process to treat an adult as incompetent and deprive an adult of his or her autonomy without an adjudication that the adult is incompetent and without prior notice and the opportunity to be heard on the issue of his or her competency. The absurdity that by this man to come out and say that if I interrupted a judge, she has the right to take my children and my money and my civil rights establishes the fraud in and of itself. You understand that, right? I mean, if I disrupt somebody in the manner in which he described right there, are you going to assign a guide ad litem to me?
I'm not subject to your questioning. I'm just listening to your argument. You make whatever argument you want to make, and if I will deal
Okay.
with whatever occurs in the courtroom and deal with it appropriately. But just give me your argument in opposition to the motion to dismiss, addressing the facts or the arguments that were set forth in that motion.
Okay. Also in Wellman, I guess it's probably best to refresh my memory that we actually read the transcript into the record, because I don't believe those facts are going to be considered.
The transcript will not be read. I can read the transcript myself. So you just, if you want me to read it, I will read it.
Well, I would like
I have
to
actually read it.
make.
You just tell me.
Well, there's a specific passage that I need to make sure that the court is aware of.
Okay, what is the specific, tell me what page that specific page is on and what you want me to read, and I'll read it.
I believe it starts on, I think 18, but let me check. Oops.
I have read that, but I will go back and refresh my memory, okay?
Well, I need to refresh my memory because this is the only opportunity to be heard, apparently. What happened? Here it is. What the heck? Why didn't it open? Over here, come open. Okay. Yeah, another thing I want to put on the record is that the U.S. Supreme Court has a precedent that has established that there's a precedent that the parents' rights cannot be determined. Hold on. I don't know this. Where is it? Oh. Oh, shoot. Without clear and convincing evidence of some parental unfitness, which never occurred. Oh, I would like to point out that, yeah, she decided to play doctor from the bench. That, yeah, that's important. That's in here. And in doing so, she acted clearly outside the scope of her duty, acting under the color of law. Acting as a mental health professional is not a judicial act. So therefore, she loses jurisdiction. And we'll go over Wellman in a second, but I need to read you that actually occurred so that you know the facts have been pled.
Again, I've read everything, so if you just point out, if that's what you want me to read, I'll go back and reread it, okay? You're talking about in the transcript, right? That's filed.
That's right.
Okay.
It's she makes the claim that I have. Hold on. Jesus.
All right, Mr. Greenberg, we need to move along. Can you find it? If you can't.
Well, yeah, I'm a slow person. I have a disability, so you're gonna have to bear with me.
Well, I've told you I would read it, so if you can find it in the next few minutes, I'll let you look for it, but we're going to move on, okay? let's move on. I will read the transcript again concerning that. Is there any other points you want to make?
Yes, I want to make the fact that
What other point would you want to make, if there is any? 'Cause we're gonna move
there
on.
are plenty.
Okay, I'm going to move on to the next motion unless you tell me something else pretty quickly. Okay.
Yeah, I mean, I guess I need to take a recess to find exactly what that is. That I need
Well,
to
I'm not
just.
ready to take a recess right now, so we're not.
Well, I am.
Well, I'm sorry, you're not in charge right now, Mr. Greenberg. We're not going, we've only been at it for about an hour and a half. I don't take a recess that quickly, so.
Well, I have a disability. I require additional breaks.
Mr. Greenberg, we're moving on to the next motion. All right. The motion to dismiss by Mr. Robinson and Mr. Woodruff.
What we're trying to do is this court doesn't find Mr. Greenberg mentally competent. That's on page 25.
All right, page 25. All right.
But it starts at page 18
I'll read the
and
whole
goes
thing.
on through.
Mr. Greenberg, I'll read the whole thing from 18 through whatever it is.
Well, I prefer you read it for the whole thing through and through.
I have, and I will again. Thank you. Now we're moving on to the next motion. All right.
Morning, Your Honor. Joe A. Helen on behalf of Judge Robinson and Woodruff. And I also represent former Attorney General Slattery and Seymour. And is it okay if I address
Yes,
that?
just address everything at one time, please.
Okay. All of these state defendants moved for dismissal for failure to state a claim. As with many of the other defendants here, there are no specific allegations against any of these defendants. There's a section of the complaint where they describe the different parties to this case, and none of my clients are mentioned in that section. As far as unique to them, the judges obviously have judicial immunity. That covers judicial acts that are taken within the court's subject matter jurisdiction. Here, there aren't any specific allegations against the judges, but to the extent that Mr. Greenberg is claiming that they made various rulings in his case when they presided over his case, judicial immunity would apply in that instance. The Attorney General and the Senior Assistant Attorney General Seymour, they both have quasi-judicial immunity, and that covers those duties that are really integral to the judicial process. I mean, as with the judges, there aren't any specific allegations against them, but to the extent that he is claiming that they took some unconstitutional action against them, he must have dealt with them in the course of their duties with the office. As far as the due process claim, I think it's important to remember that under the case law, a party may not seek relief for due process violations without first pleading and providing the inadequacy of state administrative remedies and processes. So you have to actually specify that the due process recourse that was available to them wasn't provided here, which they have not done. He's alleged a due process violation here, or that's what he claims. I'd assume he's bringing a federal civil rights case under Section 1983, and one requirement of those claims is that each defendant is personally involved with the alleged violation. As I've said a few times now, there's no specific allegations against the defendants I'm representing, but for a due process claim, there would need to be a personal involvement requirement there, which wasn't met. I think lastly is the statute of limitations. For civil rights cases, it's 1 year, and here the allegations are focused on a proceeding in 2017 in California with the appointment of the guardians ad litem. So there's no allegation of anything against my clients within the last year. So for those reasons, my clients would ask that this case be dismissed.
All right. Thank you, sir. Mr. Greenberg, anything other than what you've already told me that would be applicable to these 4 defendants? Just a moment, Mr. Greenberg. We've got to unmute you just a second. Okay, try
Yeah,
again.
he asserted the. Yeah, res judicata again, which is not applicable to void judgment because it's void from beginning to end. Regarding Rankin v. Howard, it addresses the loss of judicial immunity. It says ex parte guardianship in a proceeding would be a flagrant violation of due process, rendering any order null and void. Okay, so when Palafox went out off the bench, had extrajudicial communications with most likely Gail Hickman, which I'd like to do additional discovery on to find out what those extrajudicial communications or acts were, and then came back in the courtroom and then took away my civil right to parent my children and my autonomy, which is, you know, by sua sponte appointed a guardian ad litem, that is a flagrant violation. These judicial officers and these individuals in the state of Tennessee are aware, just as you are aware, that this event occurred. So in Relman, it says that a flagrant violation of due process rendering any order void. Because the limits of personal jurisdiction constrain judicial authority, acts taken in the absence of personal jurisdiction do not fall in the scope of legitimate decision-making, and the judicial immunity is designed to protect. B. Gregory v. Thompson. We conclude that the judge who acts in clear and complete absence of judicial jurisdiction loses his judicial immunity. These judges are refusing to address vacating a void order. They are engaging in the fraud themselves and committing additional due process violations. So if those judges knew that the jurisdictional allegations to be fraudulent by in Wellman, I think the prior decision to assign the guardian ad litem is relevant. Basically, Julie comes out and says, page 5 or 6, that she may consider it at some point later in time that if I tried to expose her in the fraud that she's perpetuating with Ms. Gifford regarding withholding my children, she was going to punish me by taking away my autonomy based on my mental illness. That's clearly facts that are alleged, and these individuals refuse to acknowledge. Fraud upon the court is committed with the representative of the court, mediators, evaluators, administrators, special appointees, lawyers, guardian ad litem, parenting time expediters, like Galindo. Fraudulently present facts to the court to that interfere with a just and equitable decision to make a decision. This man's assertion that they were entitled to take away my autonomy because Julie Palafox was frustrated in her job and duties is a clear violation of my due process, civil rights. But I mean, that can be, I mean, I don't know how I get the court to acknowledge that. And as far, again, his judge loses his judicial immunity regardless of the existence of subject matter and jurisdiction if he or she acts in the lack of personal jurisdiction. So when Julie Palafox acted as a doctor and told me that I didn't have the mental capacity, I was mentally ill, and therefore she was going to play or force a guardian ad litem on me. She clearly acted outside the scope of her duties. That can't be refuted. I mean, it can, but not without committing additional fraud. His other assertions were that the statute of limitations are barred, but there are decisions being made that are tolling in nature. For example, the constitutional harm of me not having custody of my child is ongoing, hence tolling. I'm trying to remember what his other assertion was.
Anything further then? Mr. Greenberg, on this particular one, I think you've covered it, what he addressed, but if you think of something else right now, let me know. We're going to move on then to the motion by Veritas and Jennifer Cole.
Yes, Your Honor, good morning. I'm Jennifer Daniels. Cole is my maiden name. I'm the child support attorney out of the 21st and 32nd Judicial Districts, so Williamson County Child Support Services. So I'm here on behalf of myself and Williamson County Child Support Services, which is privately operated by the state, which is, hence Veritas HHS is our operator. So, Your Honor, I'm asking the court to dismiss these claims against myself and Child Support Services as Mr. Greenberg has failed to provide any factual basis for his claims, and his claims are barred by res judicata as his issues have already been litigated in the state of California. I believe the bottom line is Mr. Greenberg is just dissatisfied with the California order. That does not in and of itself make an order void. My office and myself got involved in this in April of 2021 when Ms. Gifford requested the services of my office to collect and enforce the California child support order. She resided in Williamson County. Mr. Greenberg was here in Davidson County. So my office filed the notice of registration. Mr. Greenberg contested the registration. We had a hearing before Judge Woodruff. And ultimately, the California order was registered here in Tennessee to collect and enforce that child support. And Mr. Greenberg did appeal to the Court of Appeals, which was dismissed in March of 2022. In Mr. Greenberg's claims here today, I believe he claims intentional misconduct between me and Judge Woodruff and the California judges. He claims wire fraud and money laundering by myself and my office for just collecting child support. He claims that he was deprived his due process rights and also claims that there was fraud by California. So by registering the order that I'm committing some type of fraud and being unethical to the courts. And I would assert that none of those are true, that they are just practically just words on a piece of paper because there's no factual basis. And we would ask that the claims be dismissed by myself and the Child Support Services, please.
All right, thank you, ma'am.
Thank you, Your Honor.
Mr. Greenberg, let's get you unmuted and you can respond.
Okay, I think I'm unmuted. So the first thing I'd like to address is that the Chancery Court, in Jolly v. Jolly, Chancery Court erred in enforcing a decree that was not properly registered under the Uniform Interstate Family Support Act. She made claims that there was a valid proceeding to enforce the child support, and that's simply not true. as you're aware, the fraud upon the court perpetrated in the state of California rendered that void, that order void. There's no way you could make a valid or invalid proceeding valid, or a void judgment is void. She knew that the inappropriate and unlawful appointment of the guardian ad litem in the state of California voided the order. But she went ahead with it anyway. I did supply in the complaint the actual audio transcript and written transcript of the hearing, in which I was again denied due process of establishing or challenging the validity of the California order. At one point, Mr. Woodruff claims that that's not the way they do things in this state of Tennessee, and then I was falsely imprisoned for calling him out on his nonsensical rhetoric. But again, the document in this case, transcript and statement of record, Williamson County 0708 2821 PDF has the audio, and those are specific facts. They have dates that I assert that they committed fraud. If those allegations can be proven to be true, then they can't be dismissed. And since they're actual events, they speak for themselves. But there's more. In Tennessee, orders that are void ab initio are not entitled to res judicata. I think she tries to make some assertion that res judicata applies. Void orders have no legal effect from outset. McLaughlin, 2020, Tennessee, appellate Lexus 572. So her assertion that res judicata does not apply cannot be valid. And then there's Rule 60B, which says void order can be challenged in any court. And furthermore, there's case law that supports that it's subject to any number of attacks in any court at any time, as long as it's properly informed in front of the court. This is all my pleadings, and I would like my decision to be based on factual evidence presented, as opposed to her erroneous claims that are being spit into the record. This is not the only individual that has misstated facts. For example, the guy with the Sixth Circuit
Anything further?
Yeah, I'm concerned about the court's abuse of judicial discretion. And Walker v. Packer holding clear to only apply law correctly will constitute an abuse of discretion. Failure to apply it.
move on.
Yeah, there's one specific thing.
What would that be?
I'm looking for the cause of action.
Right. We're good.
All right, that's fine.
Now we're moving on to the motion by the Tennessee Board of Professional Responsibility and the Judicial Ethics Commission.
Good morning, Your Honor. Rachel Appelt with the Tennessee Attorney General's Office for both the Tennessee Board of Professional Responsibility and the Tennessee Judicial Ethics Committee. And Your Honor, the most important thing this court should consider in dismissing the claims against these third-party defendants is the doctrine of sovereign immunity. Both the board and the committee are formed by the Tennessee Supreme Court under Court Rules 9 and 10A respectively, and as such, the doctrine of sovereign immunity prevents suit from being brought without consent by the legislature. Article 1, Section 17 of the Tennessee Constitution provides that suits may be brought against the state in such manner and in such courts as the legislature may by law direct, and this has been codified in Tennessee Code Annotated Section 20-13-102A. And according to the applicable case law, the legislature again must consent to suits against the state. Legislature has not done so here under this set of facts and against these particular defendants. Even if the claims were not barred by sovereign immunity, Your Honor, the claims are fatal to the extent that they fail to state a claim against either the board or the committee specifically. And as mentioned previously, a Section 1983 claim for federal due process violations would depend on personal involvement by either the board or the ethics committee in the deprivation of due process against Mr. Greenberg, and he has made no specific allegations of conduct by either party, and furthermore, he cannot make any of these allegations because neither the board nor the ethics committee were involved in either the California action or the proceedings in Tennessee with respect to the enforcement of the California action. Additionally, there are statute of limitations issues with this case as raised previously. It's been over a year since the offending conduct occurred, and we would ask that this court dismiss any and all claims alleged, conclusory claims alleged against the Board of Professional Responsibility and the Judicial Ethics Committee.
Thank you. Thank you. Mr. Greenberg.
Yeah, so most recently, Andrew Campbell of the Tennessee Board of Professional Responsibility violated, let's see where I wrote it down. Confidentiality breach, Tennessee Rule 9, Section 32, when he disclosed personal information regarding my complaints to the board, which are supposed to be held in confidentiality. And then he decided to notify the TBI and tell them that I was mentally incompetent based on the fraud perpetrated by Galindo and Palafox on pages 5 through 9 in the transcript, 617, as well as pages 18, 23. Those are specific facts alleged. Regarding the Tennessee Board of Professional Responsibility, they have failed to discipline the attorneys involved in this fraud. It's tolling in nature. They allow their members to continue to defame me, cause emotional distress, personal or intentional infliction of and that is pled. I apologize to the court that each person wasn't clearly specified, and I should have said third parties, I would ask that the court allow leave of court or further right to amend to put in more facts if necessary to survive the 12.
Mr. Greenberg, these have been filed for quite some time, and this hearing has been set for quite some time, and we've spent a lot of time, and people have spent a lot of money hiring attorneys, and so we're not going to amend anything. You've had your opportunity. They are here. They have made their arguments today. So if any amendments were to be done, they should have been done prior to today, or at least a request to make those amendments should have been, so that we could have avoided being here with all of these people and wasting everybody's time if that were the case. So there'll be no additional amendment, or there will be no amendment to your complaint or your third-party complaint. It will stand as it is right now. So is there anything else you want to say with regard to these two defendants?
No, I mean, I maintain that what was asserted, that the alleged facts were sufficient to survive the 12, I mean, Rule 12, whatever, dismissal.
Okay.
But at the same time, if this court doesn't find that, I would, like I said, request that whatever remedy, or not remedy, but, well, I guess the court has already made its decision.
To the extent you are making a motion to amend your complaint, your third-party complaint or cross-claim, whatever you call it, is denied. It was not timely made.
Okay.
All right, let's move on then to Ms., I think the next one is Dean Chris Guthrie, and I think Dean Gonzalez.
May it please the court, Tim Palmer for Dean Chris Guthrie and Dean Alberto Gonzalez. Your Honor, we appreciate the opportunity to be heard today. Legal memoranda have been filed on behalf of both of these individuals. We would certainly incorporate those into our arguments today. If it's permissible with the court, I'll summarize those for you and speak jointly as to both of these individuals.
Yes, sir, that would be great.
Thank you. I guess I start to simply point out that these two individuals stand as deans of two of the most esteemed institutions in our city. Each are highly qualified lawyers, well respected in the legal community. Of course, Dean Gonzalez is a former United States Attorney General. The suggestion in Mr. Greenberg's complaint that they had any involvement whatsoever in the proceedings that he makes the gravamen of the allegations he's asserted here is both frivolous, baseless, and simply doesn't withstand legal scrutiny whatsoever, Your Honor. Frankly, I stand before you somewhat mystified as to why these individuals have been named. You can read the complaint cover to cover. The deans had no involvement whatsoever in the California divorce proceeding. The deans had no involvement whatsoever in appointment of a guardian ad litem in that proceeding. And they had no involvement whatsoever in the issuance of a child protective order or the domestication of that order in Tennessee. Rule 12, as you well know, requires that there be some legally sufficient allegation made. Here, the third-party complaint, as many others have pointed out, is filled with conclusory allegations where Mr. Greenberg throws out certain causes of action without really any factual basis whatsoever to support those, and certainly without the particularity and specificity needed to establish the facts necessary to support a claim against Dean Chris Guthrie or against Dean Alberto Gonzalez. To the extent that those claims may be asserted, or may be understood from the bald conclusory allegations contained in the complaint. They are prohibited by Tennessee's 3-year statute of limitations for issues regarding fraud. They are prohibited because they are not specifically pled, and they are prohibited, as best we can tell, by Tennessee's 1-year statute of limitations for injuries to either the person or property. So I stand before you simply to say, Your Honor, that, in 35 years of practicing, I can hardly recall a complaint or third-party complaint more lacking in legal foundation, lacking in merit, lacking in basis, and is simply frivolous. And I request that this matter be promptly dismissed as to these 2 individuals, Your Honor.
Thank you. Mr. Greenberg.
Yeah, so I
Mr. Greenberg,
recently
I would-
filed my opposition.
Let me ask a question. Can you just tell me specifically what you say your complaint alleges against these 2 individuals? Where in your
Well,
complaint-
the
what
dean
is-
that's an attorney, he's failed to report the judicial and attorney misconduct under Rule 8.3 of Tennessee Board of Professional Responsibility, and that allows this fraud to be perpetuated. He's, like the counsel said, he's a prominent member in the Nashville community or legal community. He has an obligation, just like any other attorney or judge, to report misconduct. By not doing so, he's perpetuating this fraud.
Okay. All right, then. Let's move on then to I don't believe Mr. Armanack is present, is that correct? We'll move on then to...
He's subject to do default innings. When are we going to schedule those default?
After I've ruled on these motions, I'll schedule another date to hear any remaining motions. All right, Defendant Madeline Greenberg's motion to dismiss.
John Maher, appearing again for Ms. Madeline Greenberg on a special appearance. A motion to dismiss was filed with regard to her. I didn't see any response filed with regard to her motion to dismiss. But the same things. This is at the time the divorce was going on, she was a minor. I have no idea where, didn't see anything in there, any allegations about her or her involvement in any of this. Just simply named, and the litany of people he named, I'm assuming is because he's angry with his daughter, and so he just threw her in there. But there's no material allegations against her. And I would note that there is a permanent order of protection which has been filed with the court with regard to Mr. Greenberg's contact with her and his other children. So I would note that for the court's purposes. I don't know if he used this as some kind of discovery to figure out where she lived or where she was so that they could try to create some kind of contact with her, but certainly there's no factual allegations whatsoever. It's just simply a frivolous action on his part to throw her name in there and cause her some type of grief because he can't have contact with her.
Thank you. All right, what point out in your cross complaint to me, or third-party complaint, what allegations apply to Ms. Greenberg?
Yeah, so if you look at the transcript, the 9-7, I mean, I can share it with you on the screen, which we should have done with the other one, but she was part of the fraud perpetuated to...
In California?
Yes. Where is this? Oh, no. All right, well, let me look it up. Not 7. negotiated with Palafox to not allow me to have call witnesses in my hearing. But let's see. These facts are pled in the complaint and subsequent, all right. All right, so how do I share my screen?
Well, is this the same transcript that you wanted me to?
No, this is the
Something else? Has it been filed with the court?
yes, it's part of the judicial notice. Can you see my screen?
No.
All right, let's try again. Here we go. Share. Open system settings.
I can see it screen. What are you wanting me to read?
Okay. That's fine. So here, what page are we on right here? All right, that's not apparently where it is. Sorry. Well, I'll just read it to you. I'm ready, Ms. Gifford, I'm ready with the exception that Madeline, our daughter, was subpoenaed to appear as a witness. I was not subpoenaed on her behalf, but she could not be here this morning because she is presenting her senior project for graduation. But if she is required to be here for trial, I can have her this afternoon. Why don't you grab the microphone so we can hear you? You are very soft-spoken. So you're ready to proceed? This is the court, sorry. But you're indicating that the court, that Madeline was subpoenaed and is not available because she's in school right now, working on her senior project? Ms. Gifford, she's presenting her senior project for graduation. The court. Mr. Greenberg, did you subpoena Madeline Greenberg for trial? Mr. Greenberg, yes, ma'am, I did. The court. And what is the offer of proof as to what type of testimony she is going to give to the court? Mr. Greenberg, I believe it's in the actual subpoena, and I prefer not to discuss it at this time. The court, I'm asking you, sir, what is your offer of proof of the subpoena? A 17-year-old daughter who is a protected party on a domestic violence restraining order, which is unconstitutional. Mr. Greenberg, I'm not sure I understand the nature of your question. The court, why did you subpoena Madeline for trial? But anyways, it goes on. And basically she ends up squashing the subpoena. Okay, the court, all right, well, that would be improper to reopen that. That's an issue before the court. That's not an issue before the court. So the court, if there's a request by the petitioner to quash the subpoena, the court will find the good cause to quash the subpoena. So basically, she's prejudging and not allowing me to call witnesses, which further supports my claim that this order is void. So my point being is that my daughter is involved in this conspiracy, as these facts were alleged. And furthermore, I have additional concerns regarding Mr. Mayor and his representation of my daughter. He's supposed to be disqualified as he's a named defendant in this case, and he has a conflict of interest by representing my daughter and my ex-wife. He has to represent himself. I think that's it.
All right. Well, let's move on then. Motion of Judge Joe Binkley. Okay. Mr. Greenberg, would you take that transcript off of the screen so we can see you more clearly?
Oh.
Thank you. Thanks. All right.
Good morning, Your Honor. I'm Jonathan Cole. I'm here on behalf of Judge Joe Binkley. As the court may be aware, Judge Binkley is a circuit court judge in the state here in Davidson County. For a number of years was the presiding judge here in Davidson County. And so it's a little unclear because there's no allegations against him specifically in these pleadings that have been asserted by Mr. Greenberg. So it's a little unclear if he's suing him in his capacity as a sitting judge on the circuit court or whether or not his role as the presiding judge of the trial courts here in Davidson County. But regardless, there's nothing that's asserted against him, similar to some of the other arguments been made about the other Tennessee judges in particular. There's nothing that's been stated in terms of a cause that constitutes a cause of action, much less any facts whatsoever of any action taken by Judge Binkley that would give rise to any recovery or relief sought by the plaintiff or by Mr. Greenberg, the third-party plaintiff. And Your Honor, we provided a brief and a number of the arguments that have been made. I won't repeat them. Basically, he's failed to state a claim, that there's problems even if he did state a claim, whether or not he's stated a cause of action sufficiently under the statutes for 1983 or 1986. Also, they're time barred. Anything that was taken or underdone that was done allegedly by Judge Binkley would have happened long before the statute ran. And then finally, and probably most importantly, of course, Judge Binkley is covered by the absolute judicial immunity given Tennessee judges. And so any actions that he did take, if any at all, were covered by that immunity and should be dismissed from this action.
Right.
Thank you, Your Honor.
Mr. Greenberg.
Yeah, judicial immunity is not absolute. The court is aware that immunity by judges can be lost when they act outside of their personal jurisdiction or act out of personal jurisdiction. Whatever. I mean, it's clearly established. Why these people continue to come up here and say that is absurd. I believe Binkley touched my case briefly, and therefore, in the alleged facts, he is part of the conspiracy. At one point, he is involved in the clouding of the title of my properties. He did something with the Lynn's list pendings. I guess I'll have to wait for another case to put these specific facts and allegations, even though his participation in the overall conspiracy of fraud is well documented in the pleading.
Okay. All right. Did I miss anyone that is here today to be heard? All right. Thank everyone for your patience today. I know it's been kind of a long morning. Mr. Greenberg, thank you. We will get a decision to you very quickly. I would anticipate probably next week sometime I will have it for you. I just want to make sure that I have reviewed everything. I have read everything already, but based upon your arguments today, that you get a well-reasoned written opinion from me. Anything further?
I have a question.
Yes, sir.
So those that didn't oppose or come to support their motion to dismiss, what is going to happen to them?
I'm going to read the motion. Honestly, that one I did not realize had been filed yet, so I need to read it, and if we need to set that for a further hearing, we will do so. I will be setting another motion date because there are several other motions that have not been dealt with. I'll set another motion date fairly quickly, and if need be, we can deal with it at that time, okay?
Okay, I also had a question about the judicial notice that I filed on the 27th of November. Are you familiar with that?
What's your question?
My question is when will the court
When
make judicial?
I will set a hearing date to take up these remaining matters. We'll try to take them all up on one day, okay?
So the court, you're going to require a hearing to take the judicial notice?
I'm going to address it. Understood?
No.
Well, let me look at that, Mr. Greenberg, and maybe
Okay.
I'll be able to do that without a hearing. I'll just take a look at that,
Okay. I appreciate that. Thank you.
All right.
Clarification.
Thank you, ladies and gentlemen. Court is adjourned.
Thanks. See you.